Hello, my name is Dave Giddens. I'm with the law firm of Giddens and Gatton Law, PC in Albuquerque, New Mexico. Our firm practices primarily in the areas of bankruptcy and creditors' rights throughout the state of New Mexico. I'm here today to tell you about some major changes that may be coming to the area of consumer bankruptcy law. On December 9th, 2020, Senator Elizabeth Warren introduced the Consumer Bankruptcy Reform Act of 2020, which I will refer to as the CBRA. If enacted, the CBRA will bring with it the most substantial changes to the bankruptcy code since 2005. Today, I want to tell you about the 10 major changes to consumer bankruptcy that are contained in the CBRA. In future talks, I will cover these changes in more detail and also try to keep track of where the CBRA is in the legislative process. Let's take a look at the 10 changes. Change number 1. For individual consumers, Chapter 7 and Chapter 13 of the Bankruptcy Code will be replaced with a new Chapter 10. Consumers with less than $7.5 million in total debt will file under Chapter 10. There are no more individual Chapter 7s, and Chapter 13 will be eliminated completely. Consumers with more than $7.5 million in total debt will file under Chapter 11. Change number 2. The required pre-petition credit counseling and post-petition financial management courses will be eliminated. Change number 3. Upon request, 341 meetings will be conducted remotely and scheduled so that they do not interfere with the debtor's work schedule. Change number 4. The means test will be eliminated, and rather than focus on the debtor's choices of expenses, Chapter 10 will focus on the debtor's ability to pay. If the debtor can meet a minimum payment obligation, the debtor will have to file one or more plans. Change number 5. There can be up to 3 types of plans. A residence plan to deal with mortgage arrearages, and there will be some ability to modify the home mortgage. The second type of plan is a property plan to deal with auto loans and other secured debt. And there will be a third type of plan for general unsecured debts. Change number 6. If a minimum payment obligation is not triggered, the debtor receives an immediate discharge. Most debts that are currently non-dischargeable under Section 523 of the Bankruptcy Code will remain non-dischargeable. Liens held by creditors will continue to survive the discharge in bankruptcy. Change number 7. Consumers with a minimum payment obligation will receive a discharge upon confirmation of their plan or plans, rather than upon completion of payments. If the debtor fails to complete the plan, they still get their discharge, but the trustee will liquidate the debtor's non-exempt property for distribution to creditors. Change number 8. The debtor's attorney can be paid overtime for fees earned before the case is filed. Change number 9. Student loan debt will be treated as general unsecured debt and will be dischargeable. Change number 10. Several other consumer protection laws, such as the Fair Debt Collection Practices Act, will be amended. For example, one of the proposed amendments to the Fair Debt Collection Practices Act will prohibit the filing of a proof of claim for a debt that is otherwise barred by the statute of limitations. These are major changes. Time will tell as to whether or not the CBRA will pass and become law. However, since the key provisions of the CBRA were part of Senator Warren's platform when she was running for president, and since then candidate Joe Biden adopted these as part of his platform when she dropped out of the race, I think it is likely that we will see a substantial portion of the CBRA become law. Stay tuned. In my next broadcast, we will start to look at these changes to consumer bankruptcy law in more detail. Stay safe, stay well, wear your mask, and have a great day.